Hello everyone, this is Stuti Khare from Institute of Law, Nirma University, returning under the Amikus Qriae. Today we will be talking about the misuse of power of ordinance in India. Article 123 of our Constitution tells about the ordinance. The power and authority to the President of India to issue an ordinance only when both the houses of Parliament are not in session. The circumstances exist which render it necessary for him to take such immediate actions. Such ordinance will hold good only for a duration of 6 weeks from the reassembly of Parliament. Under Article 213 of the Indian Constitution, same power is given to the governor of a state. The purpose is that the law-making power lies in the hands of the legislature, by which legislature can gauge the need of the people and give them essential representation. Then, after extensive debate and deliberation, legislatures form the law which would ensure that the provisions included are in the best interest of the people. This would keep the democratic spirit intact. The executive has the work of implementing the laws that are passed by the legislature, but during times when the legislature, both the houses, are not in session, the law-making process need not be hindered. To address any immediate concern during that time, ordinance as a tool has been introduced. As per Article 123, the President should be satisfied that the existing circumstances are of such nature that an immediate formation of law is vital. The condition of approval by the Parliament within 6 weeks of the date of convening of the session was kept for explaining the urgency of the situation. But each and every ordinance passed till date has been questioned on the urgency requirement. In major instances, ordinance was not only essential and was passed to address some political motive of the government which shakes the motive of the entire provision. In many instances, when both the houses are again in session, ordinance passing government do not enact the law on the ground of urgency for which ordinance was promulgated. Then, after the ordinance gets lapsed without getting passed in the houses within 6 weeks of reassembly, the government repromulgates the same ordinance once the house is not in session. This led to obvious disregard of the basic structure doctrine that includes separation of power. The executive taking over the power of legislature would be a fraud on the constitution. There were cases regarding the same. One of them is D.C. Wadhwa and others versus State of Bihar and others. It was held that the ordinance-making power could be exercised by the executive only when there was an emergent situation that needed redressed and it cannot be perverted to serve political ends. In the case of P. Vajravelu Mudaliar versus Special Deputy Collector, it was held that such an abuse of the power by the executive in a covert and indirect manner would be colorable legislature. If a constitutional authority does not act which is not expressly permitted by the Constitution, it would amount to the fraud on the Constitution. In S.I. Pomai versus Union of India, it was held that President's satisfaction can be challenged on the ground that it is malified or based on wholly extraneous or irrelevant grounds, though the question of reviewability is left open-ended. In Krishna Kumar Singh versus State of Bihar, it was held that the ordinance-making power does not constitute the President into parallel source of law or an independent legislative authority. The power to promulgate ordinances is subject to legislative control. Laying an ordinance before the Parliament or state legislature is a mandatory constitutional obligation. So, repromulgation of ordinance is a fraud on the Constitution. Immediate reasons for passing the ordinance could be challenged, but it is not clear whether the satisfaction of the President on such urgency could be challenged or not. Also, the executive has played trick on the legislature by repromulgating the ordinance to serve political ends. This makes the entire process of passing an ordinance questionable and qualifies for fraud on constitution. But judiciary exercise it the power to draw the line dividing powers of the other two streams. Thank you.